With that, I am going to turn the presentation back over to Becki to discuss what employers can do given the end of TPS for many designated countries. Becki?
Thanks, Sandra. So I'd like to talk about the options that we call affirmative options, which are basically the choices that are available to any worker who's here in the U.S. And has a legal status. So, for example, if an employer comes to me and they say, I have this employee and he or she has F1 OPT, or he or she has an H-1B visa, or some other legal status in the U.S., those individuals would be eligible for affirmative options. And so we're going to go through those options, even though, as you will see, unfortunately, there are some hurdles for people with TPS to obtain these affirmative options. I want to make sure that you understand, what the sort of the standard path is, and then we can talk about why it's problematic for people with TPS and what the solution to that problem may be. Before we do so, we just wanted to touch briefly on the idea of a legislative solution. So the only way to really comprehensively address this issue of TPS would be a legislative solution. And there are a few bills that have been introduced, as you can see, in the House and the Senate, which would address the TPS issue. And so we're not going to go into detail about those bills, but we wanted you to know that they exist and to suggest that if this is an issue of interest to you, that you contact your representatives and let them know that you support this legislation. So the only way to comprehensively fix the problem would be a legislative solution. We're going to be talking about some alternatives, including a judicial solution. Sandra will get to that in a minute, but the judicial solution is not a comprehensive solution, and so legislation is really the only way to fix the whole mess. So let's talk about the standard path that people would follow. So you come to me and you are an employer and you have an employee who has an H-1B, and that you want to sponsor that employee for lawful permanent residency, which is the same thing as a green card. So, which I think is actually green again. Sometimes they're green, sometimes they were pink, but I believe these days they're actually green again. And so a green card or lawful permanent residency is a status in the U.S. It's short of citizenship, so it doesn't give you all the rights that a citizen has, but it gives you many or most of the rights that a citizenship has. So it allows you to work in the U.S. for any employer without having to get authorization. It allows you to travel in and out of the U.S. Some of the restrictions are that you cannot vote in, this is local, state, or federal elections, although actually in some jurisdictions, permanent residents can vote in local elections. My city, Hyattsville, is one of them. But for the most part, you need to be a citizen and not a permanent resident to vote in elections. You can also be removed from the U.S. if you commit certain crimes. So once you become a citizen, you're no longer subject to removal if you commit a crime. But as long as you're a permanent resident, and you may sometimes read in the newspaper about longtime permanent residents being deported, and that's why, because as permanent residents, they don't have the protection that citizens do of avoiding deportation. So that's excuse me, an issue. And then finally, we sometimes see an issue with legal permanent residents who travel too much. So you do have the right to travel in and out of the U.S., but permanent residency is for someone who intends to reside permanently in the U.S. And so sometimes we see folks who basically are living overseas and they sort of travel to the U.S. every few months. They make an entry and then they go back, and they believe that they're maintaining their green card in that manner, but the answer legally is that they are probably not. So if you're not spending the majority of your time in the U.S., you could very easily lose your green card. So many benefits to having a green card, but also some restrictions. One huge benefit of having a green card is that it is a path to citizenship. So depending on how you got your green card, if you received it through employment, after 5 years of being a permanent resident, you can apply for citizenship. And if you got your green card through marriage to a U.S. citizen, and you're still married to that U.S. citizen, then after 3 years, you can apply for citizenship. So how does all of this affect people with TPS? So a lot of times, people with TPS come to us and they want to know whether they can go through the lawful permanent residency process. And the answer is they can go through some parts of it, but when they get to this final step, which is called adjustment of status, the answer becomes more complicated. So as Sandra will explain, one of the factors that determines whether they can get a green card is where they live in the U.S. So certain states have case law which says that they are allowed to get green cards, that they are allowed to adjust their status. So if they live in one of those states, or if they'd like to move to one of those states, and for companies that have operations in multi-states, sometimes moving an employee to one of those states could be an option, then they would be eligible to get a green card. Otherwise, it really depends on the facts of their case. If they're deportable for criminal reasons, or they have a prior order of deportation, that can make things more complicated. So there are a variety of factors that go into determining whether someone with TPS, as opposed to before we were talking about perhaps somebody with an H-1B, that person can clearly apply for adjustment of status. The person with TPS, maybe not. So we'll talk a little bit more about that shortly. So a really important concept, and again, we're going to try not to get too much into the nitty-gritty of legal terms because this is a somewhat complicated legal idea, but basically it's really important, if you want to apply for adjustment of status, that you were either admitted and inspected into the U.S. or that you were paroled into the U.S. And so what do those terms mean? So admitted and inspection is pretty easy to visualize. So you present yourself at an airport, at a seaport, or at a land border port at Canada or Mexico. And you have valid immigration documents. So you're coming as an H-1B, you have an H-1B approval notice, you're coming as a tourist, and you have a tourist visa. You present yourself to U.S. Customs, you're at the border, and you say, "Hi, I'm here, I would like to enter the U.S. Customs looks at your documents, they approve you, and they admit you to the U.S. So that is really good. That puts you in a great position. Most people with TPS are not in that position. Most people with TPS entered without inspection by crossing a border illegally, so they did not present themselves to U.S. Customs. So that leads us to the second possibility, which is that they got parole. So there are various kinds of parole, but the concept of parole is basically that you enter the country, so you have to depart the country in order to be paroled, and then you would present a document, and you would be, it's not technically an admission, but the Immigration Service would allow you to enter the U.S. lawfully because you're presenting that document. So if you might have heard of it, advanced parole, that's something that people with a pending green card get, or humanitarian parole, which is for people with dire humanitarian circumstances. So there are different types of parole, but basically it's a way to get into the country legally without technically being admitted. So the most important things to keep in mind is that usually in order to adjust status, you have to be either admitted or you have to be paroled. And Sandra, could you go to the next slide, please? So let's talk about, and the next slide as well, the regular employment-based process. So how does it work? You come to me, your H-1B employee wants you to sponsor them for a green card. So in order to sponsor a green card, you have to show that that employee is not taking a job from a U.S. worker. So that can be very challenging for certain jobs and less challenging for other jobs. So if it's a job that you're constantly trying to fill and no U.S. workers ever apply, that job is probably a good candidate for labor certification. On the other hand, if it's a job that, if you were to place an ad in the newspaper, 100 U.S. workers would show up, that job is not going to win you a labor certification. So the labor certification process, which is also known as PERM, is intended to enable employers to sponsor workers when they can't find U.S. workers to do the job. And so in order to prove that you can't find U.S. workers to do the job, you conduct a recruitment. And so for many of, there are two types of recruitments. There are professional and non-professional recruitments. And let's just assume for the sake of this discussion that we're talking about non-professional jobs. So restaurant bussers, restaurant servers, even I believe restaurant managers are actually considered non-professional jobs here. Someone in your finance office, so a controller, a marketing manager, those individuals would be considered professionals. But most positions in restaurants are actually not considered professional jobs here. So that's good news. That means that you only have to recruit in 3 sources. So you would recruit in your local newspaper, you would place a job order with your state workforce agency, and you would also make a posting at the restaurant. And if any U.S. workers apply, you have to see whether they're qualified for the job. So if any qualified U.S. workers show up, it has to be able, willing, qualified, and available. So if any U.S. workers show up who meet those requirements, you cannot proceed in sponsoring your foreign national. But a lot of times with our restaurant clients, when we advertise these jobs, nobody shows up. So if nobody shows up, then you've proved that there are no U.S. workers available, and you can proceed to the next step. And that's filing the labor certification application with the Department of Labor. And the labor certification generally takes about 4 to 6 months. So this whole process will take about 1 year between the preliminary steps of recruitment and then the filing step and pending at the Department of Labor. We would estimate about 1 year. Sometimes it can be a little quicker, but this will be important when we think about the fact that TPS is ending soon. If you have employees that you're interested in sponsoring, there's a premium on getting started sooner rather than later because you want to get them to the finish line before their TPS status ends. A few other things to consider: the Department of Labor could audit a PERM case. So if you file the case and they think, well, this person says there are no restaurant servers available in New York, but we happen to know that, in fact, there's a glut of servers in New York. We don't believe that they actually did a proper recruitment. They can audit your case. They will require you to submit all the documents showing that you did recruit and that you did not find U.S. workers. And that can add a year or so to the process. So audit rates are fairly low right now, which is good, but it's important to keep in mind that this step 1 can take about a year under normal circumstances and as much as 2 years if it gets audited. So let's assume that it doesn't get audited. So you have your labor certification. You've shown that that there are no qualified U.S. workers. What happens next? We'll move to step 2 of the employment-based green card process. And so that step requires the employer to show that they're financially viable. So usually that involves filing either your tax returns or, if you have them, audited financial statements. We do have a lot of employers who bulk at providing those documents, but they are mandatory. So if you're thinking about undergoing this process, be aware at the start you're going to have to provide your tax documents or audited financial statements to the Immigration Service. And also you have to show that the employee is qualified. So let's say you were sponsoring a restaurant server and you said, this job requires 1 year of experience as a server in a Mexican restaurant. So now you have to show that your employee has 1 year of experience as a server in a Mexican restaurant. So if you've done your homework, you would already have collected proof of that up front. And so you submit proof that the employee is qualified, along with proof that you have the ability to pay that employee. And this step 2 can actually be expedited. So if you file with an extra $1,225 fee to the Immigration Service, they'll process it in 2 weeks. And that's good news here where time is short. So let's move on to step 3, which is the final step of the permanent resident status. So the 2 steps that we've talked about already, the PERM and the immigrant visa petition, you can do those 2 steps for any employee regardless of their immigration status in the U.S. So people with TPS status are completely eligible to be sponsored for those 2 steps. It's step 3 where we're going to encounter an issue. And so I'm going to explain to you what step 3 would look like for someone who does not have TPS. And then Sandra is going to explain to you, because these options are not available at step 3 for people with TPS, Sandra is going to explain to you what the strategies that we would recommend instead. So normally your H-1B worker comes, you've gotten that H-1B person through step 1, you've gotten them through step 2, and now it's time for step 3. So that's the adjustment of status application. That's the actual green card application that's filed in the U.S. And that person will get employment authorization in about 3 to 5 months. It used to be 3 months, but in the past year it has elongated to about 5 months. It also gives the employee the ability to move jobs, so that's an important point. And that, as we talked about in an earlier slide, the issue is that in order to make this application, you have to have been inspected and admitted or paroled. So right now, this option, which is part of the standard process, is not available to most people with TPS. Sandra, can you move to the next slide, please? So the second option for step 3, so again, you have your employee, you've gotten the PERM, you've gotten the immigrant visa petition, and now the person needs to actually get their green card. So there's another way to get a green card, and that's called consular processing. And that requires the person to travel to their home country. And so there are a few considerations, and I guess one really important thing to think about for people with TPS is that leaving the U.S. is a really frightening idea, because a lot of times when someone leaves with the U.S. and they've had TPS, they cannot get back to the U.S., or at least they cannot get back for quite a long time. And so this option may be an option for some people with TPS, but it's very risky. And what we're trying to think about are ways that we may be able to get status for people with TPS without them having to leave the country. So with all those caveats, under the normal process, some people choose to process outside the U.S. And so sometimes that can be quicker. It is important to understand that you don't get work authorization in the U.S. during this process. If the person's in the U.S., they have to leave to have their interview. And they also have to have a police certificate from every country where they've lived since the age of 16, which for some people is not such a big deal, and for other people can be a really big hassle. But that's an important consideration of consular processing. So I think that's really the wrap-up of the standard employment-based permanent residency process. I'd like to go quickly through the family-based process, and then we'll turn it back over to Sandra. So the family-based process, in essence, this is a little more straightforward. So if your employees who have TPS status are married to a U.S. citizen or legal permanent resident, that spouse can sponsor your employee for a green card. And so the U.S. citizen or legal permanent resident spouse has to prove citizenship or permanent residence, and they also have to prove that it's a real marriage. And so there's some documents listed there that they can use. And then once that case is approved, so for spouses of U.S. citizens, both of those steps can be filed together. Again, keeping in mind this is the standard process and that there are going to be some issues for people with TPS. But normally you can file those both together. If your spouse is a permanent resident and not a U.S. citizen, there's a wait between the two steps, and so you can't necessarily file them together. But there are also issues about people with TPS, again, moving to that second step. So for people with TPS, you can do step 1, but step 2 is going to be the problematic one. And so step 2 really here mirrors what we talked about in the employment-based context. The process is very similar. The last topic I'd like to touch on briefly before Sandra discusses what options we are recommending for people with TPS status is 245I. So this is a little nugget that doesn't apply to a lot of people, but we do find that it applies to a handful of people. And so it's really important to know about, because if someone qualifies under this provision, it can be a lifesaver for them. So in order to qualify, someone, either a relative or an employer, must have filed a petition for them on or before April 30th, 2001. So that's 17 years ago, so that's a long time ago. We don't find too many people who have had these petitions filed who haven't already become permanent residents, but we have a handful of them, cases with this fact pattern right now. So if you have employees who've had something filed for them before April 30th, 2001, that will forgive an unlawful entry, and it will forgive failing to continuously maintain lawful status, which is also known as unlawful presence. So really, really important that that this question is asked of everyone who wants to regularize their status. Has anyone filed anything for you before April 30th, 2001? Because if so, this is sort of a workaround, and you don't even need to get to the litigation strategy. But if you're not so lucky to benefit from 245I, then Sandra is going to tell you what options may be available to you.
Okay, thank you, Becki. So just to summarize, Becki very succinctly went through both the employer-based and the family-based ways that an individual who's in the United States, who's been inspected and admitted or paroled, can adjust their status or get their green card in the United States. But the situation, as we saw, is very different for TPS holders, because many of them could have entered illegally, say in the 80s or 90s, and then they were granted TPS, say in 2001 if you were from El Salvador. And so you're here you're here legally in the sense that you're not going to be deported, you have work authorization, you have TPS, but you cannot adjust your status or get your green card because you haven't been inspected and admitted. So, for example, a person that came in, it is possible, for example, to have a scenario of someone that has TPS now, and they actually didn't come in illegally through the border, but they came in, say, with a tourist visa, and then overstayed, and then they got TPS. That person is in a really different legal posture because they were inspected and admitted when they came in with their tourist visa. An inspection and admission is basically a U.S. Customs and Border Protection officer looking at your documentation and allowing you in. And that leads us to this nice little map here of the United States. And as you recall, Becki said earlier that where you live, in what state you live, may make a difference. And that's because the case law in the Sixth Circuit and in the Ninth Circuit is better. And it's better because, let me go to the next slide, because in the Sixth and Ninth Circuit, the grant of TPS is considered an admission for purposes of adjustment of status or getting a green card. So TPS recipients, even if they entered without inspection and they're living in a state within the jurisdiction of the Ninth or Sixth Circuit, are in a much better position to get their green cards through one of these processes that Becki described, either employment or family-based. It doesn't mean it's automatic, by the way. Those individuals still have to show that they're admissible to the United States, that they've maintained their TPS or another lawful status, that they haven't been convicted of certain crimes or other acts that would make them inadmissible. But the point is that because of these two cases that are listed here on this slide, an individual with TPS status who initially entered without inspection satisfies this requirement of admission or inspection such that an employer could file a petition for them and then they could get their green card. So that's an important aspect to understand. Now, what about all of us who are not in the great state of California and in those other jurisdictions? So there is the kind of worst place that you want to be in the United States right now is in the 11th Circuit. So the 11th Circuit are these red states right here, Alabama, Georgia, and Florida. If you're an employer with employees in those states, you're kind of out of luck because the court in that state affirmatively held that a grant of TPS does not constitute an admission. So people that live there are not going to be able to get their green card through one of these processes that Becki talked about. In the remaining states, including where we are in the 4th Circuit, Maryland, Virginia, whether a grant of TPS is considered an admission remains an open question which is ripe for a judicial challenge. And that leads us to this slide about what can employers in the hospitality industry and in other industries do if they're outside the 6th and the 9th Circuits and not in the 11th Circuit. So the proposed judicial strategy, and this is what we are seeing immigrant advocates and immigration attorneys kind of recommend to employees who have TPS and to their employers, is that they may want to consider going ahead and filing petitions on behalf of their TPS employees anyways. So someone who is in the restaurant industry, in the hospitality industry, who has a TPS employee that is very valuable to them, that they want to support, they could go through the first 2 steps of the PERM process that Becki described. So getting the Department of Labor certification and then filing a immigrant visa petition on their behalf. And then at that point, the employee would file the 3rd step, which is the application for adjustment of status or a green card. And they would file it knowing and understanding that there is no case law right now that necessarily supports them being able to get their green card. And so what attorneys and advocates are doing is having these employees file for adjustment of status anyways, under the theory that their grant of TPS was an admission. So basically using the positive case law that was shown in the 6th and 9th Circuit. Now, there is a class action suit that's in the process of being certified or getting ready to be presented for certification that would allow persons that have gone through this process to benefit from a favorable federal district court decision, if indeed the decision is favorable. So what in essence, what attorneys are really trying to do is get courts in other jurisdictions to decide in the same way that the Sixth and Ninth Circuit did, which is basically to decide that the grant of TPS is an admission and that people can proceed to that third step and apply for adjustment of status or a green card. We note here that it's best to move quickly, and the reason for that is what Becki said, which is that, Becki, I think, how long can employers expect for those first and second steps of the perm process to take? Is it like a year and a half?
Yeah, so if the case is not audited, it could be completed in as little as a year. If the case is audited, it could be closer to 2 years, and 2 years is too long here. So, you file and cross your fingers that it doesn't get audited.
Exactly. And the fact is, if we're looking at TPS beneficiaries from El Salvador, their status is set to expire in September of 2019. So you really want to get, if you're going to kind of pursue this judicial strategy, which has some risks, but at least opens up a possible option for a green card, you'd want to do it soon to get ahead of that September 19th, 2019 deadline. We wanted to mention a few other options. We're not going to go through these individually because what's important to understand about immigration law is that the facts of each individual's case really do matter. And so you may have an employee who's a TPS holder who's never been in removal proceedings. In other words, they've never had to go before an immigration judge. And they may have as an option, having the employer file a perm petition for them, or they may have one of the other affirmative options that we discussed, like, for example, they may have a U.S. citizen family member who can file a petition for them. But if they don't have those options, they may be eligible for some of these other ones, like asylum. A lot of people who are citizens of countries that have been granted TPS, those tend to be countries where there's instability, crime, political upheaval, and asylum or protection from deportation may exist as an option. There are significant challenges to presenting an asylum claim, not least that asylum seekers usually have to submit their applications within a year of entering the U.S. There are exceptions to that rule. For example, if you've been in another lawful status in the intervening years, but there's still complicated cases that have credibility determinations and require presentation of evidence. But it's good to know that that may be an option for your TPS employees. Additionally, when someone files for asylum, and while that asylum application is pending, those people will be able to apply for work authorization after 150 days. There are also other visas known as law enforcement visas. It's good to know that these exist. The U visa exists for people who have been the victim of certain kinds of crimes and who've aided in the investigation or prosecution of that criminal activity. They may be eligible to apply for a U visa and eventually get their green card. They may be eligible for a T visa, which is for victims of trafficking into the United States. There are also waivers. If you have employees, and I'm talking about this provisional waiver, if you have employees who have certain qualifying U.S. citizen or lawful permanent resident family members, they could have an employer or a family member file a petition on their behalf, and there may be a way for them to get a waiver granted. They would need a waiver because of perhaps periods of unlawful presence that they've accrued in the United States. If they get a waiver, they can then leave the United States and consular process. Also, for very, very compelling cases, like if someone has a serious illness or a family member with a serious illness, they can apply for something called deferred action with the U.S. Citizenship and Immigration Services. Other possible options, again, depend on if the person is in removal proceeding, which means that, they've caught the attention of the U.S. Immigration Service. The U.S. Immigration Service has made a determination that they're here and they're not in valid status or they're deportable from the United States. Those people may have some other options that they can apply for in front of a U.S. immigration judge. The one I'll highlight here is this 10-year cancellation of removal. For people that have been in the United States, even if they entered illegally, but they've been here for 10 years, they're persons of good moral character in that they aren't disqualified for certain crimes. They've perhaps paid their taxes. And they're here in the United States, and they can prove that if they're deported, it would cause extreme and unusual hardship to a U.S. citizen or lawful permanent resident spouse, parent, or child. A judge may actually cancel their removal and grant them a green card. Again, this is for people that have already been placed in removal proceedings. And just the final category is for people, even people, you may have TPS employees that actually have removal orders. You may not know that they have removal orders now, and these are really more Hail Mary solutions. You don't want to be in a position where TPS is terminated and you've got a previous order of deportation, but if you do, you can file a variety of different motions to reopen before an immigration judge in order to be able to apply for relief from removal, such as asylum, or if you have other compelling equities in your case, you could ask a judge to cancel your deportation. Again, these are not easy options, and they're kind of a last case scenario. So the issue of TPS is complicated, and it really does require an individual assessment into each person's case. And so this is where it would be important for employers and employees to consult with an attorney to make sure that indeed their employee who is a TPS beneficiary might be eligible for some kind of change of status or relief from deportation. And I don't know, Becki, if you want to add something else to that?
I do not have anything else to add to that, so I think we should see whether anyone has any questions for us at this point.
Yes, if anyone has questions, you have a question tab on your screen, and we welcome questions. We don't have any at the moment. But there was a lot of information given in today's presentation, and I want to thank Becki and Sandra very much. As the attendees have heard, it's a complex situation and requires a lot of individual attention. So if you have questions, you're welcome to ask them now, or if you would like to email myself, my email is edaves@restmex.com, and I can always be reached through the magazine's website, elrestaurante.com, or as you can see on your screen now, Becki and Sandra's emails are there.
Well, and I hope we haven't frightened anyone with all of the information we provided, but you have our contact details, so you can feel free to follow up with us directly as well if you have further questions.
Great, thank you very much. Well, since we don't have any questions, let's go ahead and conclude this webinar. Thank you both, Becki and Sandra, very much. This information is very helpful. And attendees, this will be posted The recording of this will be posted later, and also the slide decks, so you can look at those and peruse them at your own time. But thank you, everyone, very much for your time today, and hope that you will be able to attend future El Restaurante webinars. Thank you.
Thanks, Ed.
Thank you.